Namaste, good evening everyone. I'm CA Shubham Dangaj, the moderator of this webinar. We are delighted to welcome you all to this webinar, which is being organized by CP Committee of ICI. Please block your calendar for CP webinar on Wednesday and Friday. It is my pleasure to be moderator for 72nd webinar on SME listing and the Digital Personal Data Protection Act from 4 p.m. to 6 p.m. In a short while, we will start with this webinar. First, I would like to apprise you about the CP community. In today's ever-changing uh, professional scenario worldwide, the biggest challenge the professional face is how to stay on the top of their game while adapting to new requirements and norms. Therefore, it is imperative to aim to be up to date, to offer unique guidance, influence other with their innovative approach and expertise. It is also vital to stretch old ideas beyond traditional boundaries to create new perspectives. In this context, CP facilitates professionals to maintain, improve, and broaden their knowledge, skills, and expertise required to achieve their professional goals through webinars, seminars, and etc. The program for this evening is as follows. We have two sessions of 1 hour each, and the topics are first, SME listing, gateway for professional opportunity. Second, the Digital Personal Data Protection Act, DPDT Act, safeguards and opportunities for CA. Our eminent speakers will talk about the above mentioned emerging areas of professional interest. Now, first session of this program will be taken by CA Ashok Khulani sir. Sir, he has 24 years of experience in Indian financial market, beginning his career in CA and later serving as founder and non-executive director of SEBI registered category 1 merchant banking firm, guiding companies through capital market listing and regulatory framework. He has led and executed 15 public listing, including 13 SME IPOs and 2 main board IPOs, raising over 1,300 crores with deep expertise in transaction structuring, due diligence, regulatory compliance, stakeholder coordinations, and end-to-end deal execution. He served as a Chief Investment Officer of a SEBI registered Category 1 AIF with a corpus of rupees 4,000 crores, overseeing investment strategy, fund deployment, and portfolio monitoring for a diverse investor base. He has extensive command over SEBI regulation, the Companies Act, the Income Tax Act, and the capital market legislation, advising corporates on IPOs, QIPs, private placement, valuations, due diligence, and regulatory document, while contributing to policy discussion, investor protection initiative, and governance standards. Sir.
Thank you, Akshat. Thank you, Shubham. Hello, everybody. Myself, Ashok Holani. I'm a chartered accountant, qualified in 2000. I'm presently running a merchant banking firm, Holani Consultants Private Limited. So we do all types of IPOs, SME IPOs, and main board IPOs. And the topic for today webinar is gateway for professional opportunities for CAs in SME listing. This topic is of immense importance to me because I fully involved in this particular process. And being a chartered accountant, I started my career as a practicing chartered accountant, and thereafter seeing the opportunities this sector portrays, I slowly and gradually migrated from a traditional practice from auditing taxation to a more informed practice of fundraising the funds and getting the company listed on the stock exchanges. So my experience in this field is immense, and I've also guided my fellow chartered accountants what are the opportunities for the chartered accountants are there in the SME IPOs so that they can benefit by doing this type of work also. Thank you. So let's go and understand what is an SME IPO, and then the opportunities really collaborate and do the work. The first thing, what is an SME IPO? What does an SME IPO helps? As per the study, around more than 80% of the mid-size or small-size chartered accountant firms are engaged in raising the finances to their clients in addition to the auditing, taxation, and other advisory services they render to them. The generally source of the fundraising is the banks and the market borrowings. But they have their own drawbacks, merits, and demerits. The more obstacles are getting the arrange the collateral securities for the clients, make the ratios comfortable, make the project reports, and etc. And that too, bank has a certain parameters for lending. So that's why on their more ambitious project or more big projects, they always fell short of the required funds. So this is the area where SME IPOs helps your client to raise the requisite finances and do their projects more appropriately, more timely, in a most friendly way. So SME IPO helps to you and to your client to raise money which is required for their projects. So this particular things helps you. What are the benefits of getting the IPO? Is to raise a credible. What are the SME IPO gives benefits to the investors, to the public, to the everything is well, is the three major points. One, it is a credible marketplace. Here you can come and get your company listed and raise the requisite funds from the public at large. Secondly, it also opens up opportunities for informed investors to invest in a growing companies who have a growth plans but lacking funds to execute their projects. So SME IPO acts as a bridge between a issuer company and the investors. So the investor can park their money into the company and the company can utilize that particular fund to raising their exciting to fund their exciting good plans and to create the business model which they want to have and stop and give themselves a good profitability and also to the investors who have invested into these companies. The process for SME IPO is a very simple process. We all do on a regular basis when we do auditing or a taxation for a company. It's a very transparent and simple process, which will I will explain you in detail in the following paragraph, following sheets also. That will help you to understand what are the opportunities are there for a chartered accountant in SME IPO. Friends, before understanding what happens in SME IPO, I will list down the steps which is taken to get a company listed on the stock exchanges where they can raise the money, and it will also opens a gateway for a chartered accountant to increase his revenue from its clients. The first and foremost, to start an IPO journey, any company needs to appoint one merchant banker who will oversee the entire IPO process. Thereafter, once the IPO process kick off by appointment of the merchant banker, the second steps comes is the IPO simulation and the planning. In IPO simulation and planning is what we do that in which we decide how much the company will dilute its shareholding to the investors who wants to invest money into this company and at what price the shares will be offered to the general public for investment and the company can raise money from the market. So this is the most foremost important point in any SME IPO journey. So here the role of the chartered accountants comes into the play initially with the time of planning the IPO. Then the issuer company, who's generally a small company who's coming onto SME exchange, then they generally depend on the chartered accountant for their expert advisory services. So here the chartered accountants come into the picture and it helps them to promoter to guide at what is the basic appropriate dilution for a company to go for its IPO. Basically, IPO is what? Initial public offering. It's the first offering. So the company wants to initially do not dilute much of its equity holding in the company, but wants to raise money. So to understand what the appropriate ratio to dilute their equity holding and at what price, this particular thing is helped by the chartered accountants to help their client to understand this. So generally, as per SEBI regulations, 25% is dilution is mandatory for any company to get listed on the stock exchanges. And it can go above 25%, but it cannot go below 25%. It can go to 30%, 35%, 40% as per the needs of the company. The second thing is comes at what price are these shares sold to the investors. So at this time, there are various ratios which we derive with the help of the chartered accountant, with the help of the company management, is the P ratio, the EPS, the NAVs, and on that basis of it, and getting the peer valuation also for a similar type of companies who are already listed on the stock exchange, with getting the one particular value, and this is the price at which we plan to offer the shares to the public, and also deciding the number of dilution of shares. So when we both combined with the number of shares which we want to offer, multiply by the price which we want to offer to the client, we get the IPO size one of that particular issuer company. After deciding the IPO price, the number of dilutions, and a total issue size, we go to the further process of getting the company ready for the IPO process. This is known as corporate restructuring. So the generally company comes, it's a family owned company and there are two directors or three directors in a company. So we convert this company into the more corporate form by appointment of the independent directors in the company, by changing the designations of the directors from the managing director to the whole-time directors to the NEDs and the independent directors. Thereafter, we appoint various committees in this company as per the Companies Act. Also the role of the chartered accountants come into the picture. They help to identify who will be the best persons for getting the on board as an independent director in the company. They also help in formation of the committees, also help to how the process of committees runs, how the committee reports to the stock board of directors. So at every point of time, the chartered accountant is helping the company to get into a corporate form from a normal issuer company before the IPO process. The next thing is the preparation of the offer document. So this is the stage where the expertise of the chartered accountant is must for every issuer company. They also hire a merchant banker who advise them, but to get the documentation done, which any merchant banker require to get your company listed on the stock exchange, we need the expertise of the chartered accountants. So every company fall back on its regular chartered accountant or statutory auditor or its their advisor, whatever, to help them in getting the documentation prepared for submission to the merchant banker for onward process. The documents can be of various types, which I will explain in detail in next slides. So this also opens a great professional opportunities for a chartered accountant to help their client to get listed on the stock exchange. So these are the procedures which I was talking about, what a chartered accountant do in a particular IPO process and helping the clients to raise money and getting listed on the stock exchange. The first thing I told you is the appointment of the merchant banker and preparation of the IPO simulation model. Second is the selection of the stock exchange platform for listing. In SME IPO, as per the SEBI regulations, you can either list on the NSE platform or on the BSE platform. You cannot list on a both platform. So it has to be decided before the start of the IPO process at what platform you want to list your company, either on NSE or on a BSE. Thereafter, after finalizing the IPO process, the merchant banker, the stock exchange platform, then the restructuring of the capital structure is done, in which, as I already told you, the company needs to decide the dilution, how much they want to propose, how much they want to dilute their equity holding. Generally, they have 100% holding before the IPO process. And as per SEBI guideline, 25% needs to be diluted to get listed. So they want to stop at 25%, they want to go for 30%, here the expertise comes. So whatever the dilution they have decided, then the need comes is to raise the authorized share capital of the company from a smaller amount to a bigger amount to absorb the new issue of the shares via the IPO process. So here the chartered accountant helps his clients to appropriately determine what will be the authorized capital of the company so that it can accommodate the fresh issue of the shares to the investor for raising the money, because every increase in the authorized capital, it's a costly affair. You need to pay a fee to the MCA, and to ensure that it is not a waste of money, you appropriately pay the whatever is required. That has to be done by the chartered accountant. Thereafter, the merchant bankers require who will be the promoters of the company to identify, because the project chartered accountant associated with the company for a very long period of time. He knows who are the persons who are behind the show, running the company on an actual basis, who are the shareholders of the company, who are the person on whose instructions or object instruction the board of directors acts. So these his knowledge help us in identifying who will be the promoters of this company, and accordingly the documentation can be started. Also, sometimes we observe that every issuer company coming for an IPO has a very small capital base. They have a huge reserves in their balance sheets, but the share capital is generally 1 lakh, 5 lakh, or 10 lakh rupees. That doesn't help for doing an IPO process. So eventually, the company generally resorts to a bonus issue of the shares before the IPO process. So here the role of the chartered accountants come into play. They help the company to determine the appropriate capital structure, how much bonus issues can be planned for this company, and the process and what the reserves they have in their balance sheet, which they can utilize for issuing the bonus shares. Thereafter, due diligence process starts, where the merchant banker demands 360-degree data from the company to understand the proper working of the company, and the chartered accountant being a finance guy understands the corporate law, the income tax or sales tax or the accounting standards. He helps the merchant bankers to understand the company and provides the data for a company to get its offer document prepared. So these are the major areas where the chartered accountant expertise are required. In addition to that, to convert a company from a normal private limited to a public structure, then these works are need to be done. They can be done by a company secretary, but they can also be done by a chartered accountant firm. Generally, these are from converting a company from private limited to a limited company, adopting the new articles which are required to incorporate all the regulations which a public limited company is required to adopt. So generally, table 6, table C are taken into care while incorporating a private limited company. But for a listed entity, there are different sets of articles they need to adopt. So the merchant banker helps the issuer company to frame that new articles which are aligned with the SEBI laws, with aligned with the SEBI guidelines, and do that. Then the board structure, majorly the appointment of independent directors, the formation of the various committee like audit committee, nomination committee, remuneration committee, uh, CSR committee. See, these all are held by the chartered accountants. Also, the company needs to appoint who is going for an IPO, key managerial persons like company secretary, who will be the compliance officer of the company, or a chief financial officer who also has to be chartered accountant. And in addition to that, audit committee chairman, as per SEBI guidelines, needs to be a chartered accountant. So these are also areas where the chartered accountant can provide their services to the issuer company. Thereafter, the most important document in IPO process is the IPO resolution. This resolution, which is passed by the board of directors and the shareholders of that particular company who is proposing to get listed on the stock exchange, is the most important document. In this particular resolution, the company plans its IPO process, the number of shares they want to dilute, price they want to dilute, but whether they want to do a pre-IPO or not, whether they want to cap certain reservation for one particular of investors, like they want to go for an employee reservation quota or a market reservation quota, market maker, or they want to appoint so many, so merchant bankers, the lawyers, the escrow accounts. So all are need to be identified and are captured in this particular resolution and get it approved by the shareholders and the boards. So this resolution needs to be drafted in a well informed way so that all the areas need to be covered in this. Otherwise, any default is there, any fault is there, then entire IPO process get jeopardized. One of the most core thing in an IPO process is the financial statements restatement. This is the core area where the chartered accountant provide immense valuable service to any company who wants to get listed on the stock exchange. Friends, in the IPO process, the balance sheet which we prepare on an annual basis is not reported in the DRHP. Instead, the financial statements are restated, and that restated financial statements are reported into the offer document. So these financial restatement has to be done by our chartered accountant who should hold a peer review certification from the ICAI. So this is the most stringent requirement, and that financial statements is not only for 1 year, 2 years, it's for 3 years. And if an IPO is coming up in the later part of the year, then stuff will also come into the picture. So any chartered accountants need to have its financial statements restated by another chartered accountant who should be a peer review auditor for 3.5 years. So this restatement opens a gateway for any chartered accountant firms to do an audit for that company, and it has to be audited in such a manner there should not be any qualifications in this audit report. Entire thing has to be taken into the care, and the provisioning has to be made in the financial figures. You cannot just write out if this provision is not done. You have to do the provision, have to have identify the impact of that particular non-compliance, and you have to take into monetary consideration and put the same into the provision into the balance sheet and come up with the true figures of that company, and on that basis is the valuation of that IPO depends. So in the restatement, every chartered accountant needs to ensure that it complies with all the accounting standards which are published by the ICAI, are duly complied in all respect in that financial statements, and then the balance sheet comes and that is reproduced in the DRHP. So this gives immense opportunities for the chartered accountant to do the work for the company and get a good remuneration for their services. In addition to that, since it's an IPO process, entire process is digitally. So every shares of the company which are already issued or any new share which need to be issued in future as per IPO process are to be in a demat forum. So the company needs to appoint a share registrar, get their ISIN generated, and all the future shares should be issued in a digital form only. In addition to that, a proper legal due diligence is done for a issuer company who is proposing to go on the stock exchange. The lawyers vet the data of not only of the income tax, GST, excise, ED, CBI, civil case, criminal case, every court they search for the promoters, they get their data and duly compile for any litigations. So generally lawyers take the help of the chartered accountants to understand the legal framework of the company and do their due diligence in a more informed way. Because it is the first of the chartered accountant who is doing the auditing or looking after this company, knows all the information about the company, and they being a more informed about the legal matters, so they help the lawyers to complete the due diligence process. So still now you can understand that at every point of time in the IPO process, the role of chartered accountants is immense. They help the issue company to get listed on the stock exchange, and doing compiling every steps. So without the help of the chartered accountant, an SME IPO cannot be completed. So what I mean to say to the friends, it is not about a for SME listing. It's SME listing is also opportunity for a chartered accountant to help the company to get their funds. So the what are the avenues for that? It's SME IPO itself a opportunity for a chartered accountant to help his client to raise the money to get them listed to ensure that they are fully compliant. And in the IPO process, during the IPO process, there are so many areas where they can help the company to get listed on the stock exchange. The area on a summarized form where a chartered accountant expertise are required by issuer company to get listed as so many things like financial leadership in like appointment of the CFO who has to be a chartered accountant, restatement for the financial statement for the regulatory compliance, comprehensive due diligence of the company operations and finances. Because when an IPO is done for any company, the information from the since incorporation till today is captured. So all the information, not only from the 1 year, 2 year, 3 year time frame that's are reported in the stock is on the restatement, but entire data is captured from data of incorporations. So that is the basic area, and every chartered accountants is helps the company to do this particular work. Then the governance and the compliance section, where the chartered accountants having the expertise can help the company, is like formation of the statutory committees, formulation of director remuneration appropriate to as per company law, deciding the designation of the directors, who shall be the managing MD, who's full-time director, independent directors, help the company to determine the composition of the various statutory committees, who can be the better person who can add value to the company in their committees formation. Also, friends, when any IPO is done, there are required around 30-35 certificates from a chartered accountant in the various areas. So they all the chartered accountant also help the company to provide these certificates, which is required by a merchant banker to prepare the offer documents. The next one is the capital structure management. The chartered accountants helps their clients to decide how much they share capital they need to or increase in the ROC, how much they share need to be issued for doing the IPO. If the company wants to raise certain money before the IPO process, जैसे generally we call them as a pre-IPO placements, they also help in getting the documentation done for the pre-IPOs. We need to have a valuation of the company before, which either can be by DCA method or a book value method or any other method. So chartered accountants helps the company in determining the price appropriate for the pre-IPO. Also, they help the company to determine the bonus issue size, what amount of reserves they have, how many they can convert into the equity, how much they need to be carried on in the balance sheet, what will be the optimum pre-IPO capital structure of the company from the conversion of a company private limited to a limited company. These are the services which are need to be provided by chartered accountants. So we as a chartered accountant can gear up and help our client to do this IPO and also survive provide so many services to them. So which also opens a gateway of opportunities for us. It is just not that we depend only on the auditing, taxation, or advising. We can provide gamut of services to our client in via the SME IPO process. The matter does not end here only. After listing, every listed company needs to comply certain rules and regulation on a timely basis for a main board IPO for 3 month basis and SME IPO on a 6 month basis. So it's not just IPO process when we have the particular assignments. Even after the IPO process, we need to provide them services on a regular basis. What are the services which we need to provide after the IPO process? Is the internal auditing. It's mandatory for a listed company to always have an internal auditor in addition to the statutory audit. the risk management system, the policies, the norms, the corporate filings, the half-yearly annual audits as per listing requirements, annual compliance certification, the governance reports, the various certifications which need to be filed on a half-yearly basis, on a quarterly basis. They need expertise. Every company needs expertise or a chartered accountant to help them to compile these type of certifications. In addition to the services which I have told you, there are also the various areas which a chartered accountant can immensely contribute to their clients. Is the key agreement advisory. In the IPO process, there are so many agreements which are executed during the process of the IPO, like managing director agreement, shareholders agreement, issuer agreement, market making agreement. So they can provide their expert services in helping the company to draft a proper agreement with the merchant banker, with the other stakeholders in the IPO to get their company listed on the stock exchange. Second is the corporate governance. It is just not about complying with the IPO process. Once you get listed on a stock exchange, then immense responsibility is come on the company to be fully compliant with all the corporate norms at all times during their listing tenure. So here the expertise of the chartered accountants comes into the play. They help the company to ensure that they remains corporate governance compliant at all times by filing the requisite information on a regular basis, timely basis, on an accurate basis. In addition to the corporate governance norm, they have a listing compliances which we need to follow the guidelines which are there in LODR, SEBI LODR, and the SEBI ICDR. So, being a chartered accountant who knows the laws, who understand the laws, are able to understand what are the required by SEBI for a listed entity, which is written in the LODR or ICDR, and they can help the company to understand these law provisions and guide them to comply with them. The fourth, the most important comes after the listing is the PIT regulations. These are the prohibition on insider trading regulations. The CA, being a legal guy or technical guy, understand the law, corporate law, everything, helps the issuer company to understand what are the do's and what are the don'ts, which has to be observed by the issuer company after listing. So they help the company to follow this insider trading regulation very vigilantly, very cautiously, and ensure that there should not be any non-compliances which can affect the company credibility in the legal structure. So overall, there are so many opportunities for their chartered accountant during the IPO process, before the IPO process, after listing. So which helps the client to raise the requisite money. And in the meantime, the chartered accountants can earn a good remuneration from their client from various services which I just informed you. So friends, this is all about the SME IPO and the opportunities which a chartered accountant can take from this listing. Thank you.
Yes, sir. Now question answer round. So first question is from CA Anup Kumar Sangi from location Kolkata. Question is, what is the minimum money could be raised in an SME IPO, and what are the prerequisites for bringing a SME IPO, like top line of the company, bottom line of the company, vintage requirement, qualification of directors, and requirements related to CS, company secretary.
Yeah. The eligibility criteria for any issuer company to get listed on the stock exchange are these are as under. First thing, the company paid up share capital should not exceed 25 crore after the IPO. I mean 25 करोड़ की कैपिटल होनी चाहिए कंपनी की आफ्टर द IPO. So before IPO, they ideally should have a capital of 15-16 crore so that 25%, which is the mandatory benchmark for a company to get listed on the stock exchange. So after the IPO, 25% is the capital the company should observe. There is no restriction on the number of turnover, कितना turnover होना चाहिए. It can be any turnover. The benchmark is the EBITDA or EBIT number. The company should have an operating profit for last 2 years out of the 3 financial years. The thirdly, company should have a website. The company promoters should not be barred from the CA, from the SEBI, and these three are the major guidelines. So there is no
Okay.
restriction on the turnover. There is no restriction on the promoter should be a chartered accountant or a company secretary. It has to has experience in that particular line of business for 3 years.
Okay,
And
sir.
as far as the IPO size is concerned, there is no restriction on the IPO size. It is only the exchanges, they have an internal guideline that the company should come up with an IPO of at least 10 crore and plus.
Okay. So, sir, next question is of Avdesh G from Rajkot. How to calculate rough value of IPO size based on the profit of the company?
Yeah. So generally, SME IPOs nowadays commanding a price to earning ratio 10 to 15, between 10 to 15. So you can multiply the profit of your company by the multiplier of 10 to 15, and you can get the entire valuation of the company. And then as per your dilution, you can, if you want to go for 25%, that let's say you have a profit of 10 crore and you want to have a, the merchant banker is proposing a multiplier of 12 times P multiple, then the valuation of company comes to 120 crores. And if you want to dilute 25%, so 120 crore or 25% is the IQ size.
Okay, sir. Uh, Anup, sir, next question is from Kolkata. What is the ballpark cost figure for bringing a SME IPO? Means what is the approx total cost for bringing a SME IPO? So, cost for bringing an SME IPO.
So SME IPO cost has various except like a merchant banker fee, underwriter's fee, NSE, BSC, NSDLC, DSL, registrar, lawyers, chartered accountants, company secretary, marketing cost. So that depends upon the size of an IPO. So we cannot go for a ballpark figure for one particular thing. I can just give you a hint of an idea. It's come around 8 to 9% of the IPO size.
Okay. So next question is of Jerome from Chennai. Is there any software to handle PIT?
Yeah, there are many softwares in the market. You can install them, you can buy them and run them.
Okay. Next question is of Pradeep sir from Bangalore. How is the valuation determined? It is related to EBITDA or PAT. What is the maximum PE allowed on SME? How is the cost of the IPO determined? IPO cost is determined.
So can you repeat the question, please?
Yes, sir. How is the valuation determined?
Okay,
Is it related to EBITDA or PAT?
okay.
What is the maximum PE allowed on SME and how the cost is determined?
So one is the what is the valuation determined of benchmarking? It is always a PAT is the benchmarking for the IPO valuation. Because in IPO process, what you offer to the investors is the equity shares. So equity shares are the those shares the only EPS is value is material to them. EBITDA is the earning before interest tax depreciations. So you have to deduct interest which is paid to the lenders who are above the equity shareholders. Then to the tax authorities, they are above to the from the shareholders. So what is left for the investor is the EPS, and on that basis, which is derived after getting the PAT, profit after tax. So always a criteria for the valuation is the PAT figure, not the EBITDA figure.
Okay.
Secondly, is the what will be the highest P multiples. There is no restriction either by the SEBI or either by the any exchanges about the P multiple. It is the merchant bankers or the company at what price they can convince the investor to invest money into their company. SEBI or exchange doesn't dictate on this is their number maximum price to earning ratio you can take. You can take anything provided you can are able to subscribe that IPO. And the third one is
Sir, cost that you have
cost. I
already.
already told you in the last question.
Yeah. So next question is of Sarvesh sir from Udaipur. How to how to do pre-IPO simulation? And continuing, can you give sector or industry-wise PE and also valuation method for different sectors?
You can get the average P for every various sectors in various platforms like Money Control, Chittorgarh.com. There are there. We help we take them from market only, and even we also do our internal exercise to understand the companies of same sector who are listed on the stock exchanges. We can get their financial from the public platform, get their EPS, get their profitability, number of shares, and arrive the price to earning ratio of them.
Okay. So next question is of Rohit Tendulkar sir from Kolhapur. For how many years we must apply India's retrospectively?
India's
Yeah.
3 years, 3.5 years, and if there is stub period also, then 3.5 years.
Okay. Next question is of Prakash sir from Thane. Is it necessary to have a profitability record for 3 years?
It is not necessary for 3 years. 2 years mandatory operating profit should be there. But for any SME company, if loss-making company comes for an IPO, it is not well welcomed by the investor community at large. So we suggest you to always go for a company who has a profitability track record in last 3 financial years. Because
Okay.
SME platform is a very niche platform. There
Yeah.
are limited type of investors are available. In the main mode IPOs, their application size is only 14,000 rupees minimum application. For an SME IPO, minimum application is more than 2 lakh rupees. So only the limited investors invest, and they only prefer a company with a strong growth momentum, growth trajectory, so they can invest their money into that company.
Okay. So next question is of Ajay sir from Odisha. Sir, what is the minimum age of SME company to go for listing IPO?
3 years plus.
Next question is of Abhishek sir from Jaipur. What is the criteria for some companies to go to main board?
Every company is eligible to go to main board after satisfying the following parameters, which are as under. The first, the company should be listed on the SME platform for 3 years. Before 3 years, they cannot go to the main board. After completing the 3 years, they need to have approval from their shareholders and the board of directors to migrate to the main board. The third is the most important one. Their net worth should be 75 crore plus. The fourth is their shareholder has to be 1,000 shareholders they should have before going to the main board. Their paid up share capital should be at least 10 crores. These are the major points for a company to migrate from SME to the main board.
Yes, sir. Next question is of Alok sir from Noida. Sir, what is the minimum size of IPO? Who has 5 crore paid up capital? Maximum 25 CR capital? Can be generate that is additional 20 crore.
So
So,
you are talking about the face value. The IPO doesn't run on a face value, it can do on a premium basis. So determine the price is your profitability, not the share capital.
okay.
What I told you is the eligibility criteria. Your share capital should not exceed 25 crore after the IPO. So you can issue your share of which is of a face value of 10 rupees at 20 rupees, 50 rupees, 200 rupees, 500 rupees. That depends upon your profitability, not your share capital.
So next question is of Avdesh sir from Rajkot. Whether India is applicable to SME listed company?
No, India's is not applicable to the SME company. It is a voluntary thing. It is applicable mandatory on the main board companies. But you
Next,
have to done the restatement, which can be done for a gap companies also.
next question is of Subramaniam sir from Bangalore. Normally, how much time it may take to complete the whole process?
Correct. Generally, if a company is compliant and is fast in giving the documentation to a merchant banker, this entire process is only for 6 months. from
Next question.
starting to the listing of the company on the stock exchange.
Next question is of Bhupender sir from Mohali. 2 years profit is a rule or a norm?
It's a norm. It's
Next question is
operating profit, positive operating profit. Profit can be a 10 lakh, 25 lakh. It is a norm.
Next question is of Swadesh Mathur sir from Gurugram. If an existing partnership firm is converted into a limited company, what is the requirements of its track records and its eligibility?
Earlier, the company can go for an IPO as soon as it converted into the from a partnership firm to the listed entity. But recently, the SEBI has changed the regulations. If a partnership firm or proprietorship firm getting converted into a private limited or limited company, then they should have a 1 year cooling off period, and thereafter they can file for offer documents.
Thank you, sir. Thank you, sir, for a great session. I'm
Thank
sure the
you.
participants have gained immense knowledge from your experience. Thank you, sir. Thank you for your valuable time.
Thank you. Thank you.
Total number of participants for this webinar are 700. Now, we will move to second session of this webinar. First, I will read the profile. C.A. Siddharth Agarwal, sir. He is a result-oriented chartered accountant and law graduated with 8 years of specialization in taxation, succession law, real estate laws, and data protection. And his empowerment as a peer reviewer with ICI. He served as the youngest professional director of Smriti Nagrik Sehkari Bank, the largest urban cooperative bank in Madhya Pradesh, providing governance and oversight for business portfolio exceeding 1,100 crores. He has strong technological proficiency with ICI qualification in DISA, forensics, audit, and fraud detection, and artificial intelligence, and manage a diverse part, practice in multi focus on DPDT Act, RERA succession, and emerging technologies. He is an active professional speaker and mentor, delivering keynote sessions at ICI platform, guiding over 3,500 CA aspirants, serving as a panelist for ICI AI Hackathon, and being shortlisted for ICI AI and DWB Faculty Identification Program. Sir. Sir, you are on mute.
Am I audible now?
Yes, sir, you are audible now.
Yeah. Thank you, C.A. Shubhamji, for such a wonderful introduction. Good evening, everyone. Special thanks to the CP committee under the chairmanship of CA Satish Kumarji Gupta Sahab and CA Vishnu Kumarji Agrawal Sahab for this opportunity. Today, we will learn about the safeguards and opportunities that are available for we as a chartered accountants under the Digital Personal Data Protection Act 2023. There are various number of safeguards because as a chartered accountant, we are collecting the data, personal data of our client. And the moment we collect the personal data of our client, we become the data fiduciary. And there are n number of obligations that are imposed on in the act on the data fiduciary. Similarly, there are various opportunities which are provided in this act for chartered accountants like consent management mechanism. Chartered accountant can play a pivotal role in implementing consent management mechanism. Grievance redressal system, grievance redressal mechanism is in another area where chartered accountants can leverage their expertise. Data auditor, data protection, risk assessment, data protection officer. So these are some of the areas, consent manager, where a chartered accountant can leverage his expertise. So with this, I will start sharing my screen. Kindly confirm me if the screen is visible. Is it visible, sir?
Yeah. Please
Okay.
share. Please go. Carry on.
Perfect. So this is it. The DPDP Act safeguards and opportunities for chartered accountants, navigating compliance and unlocking professional opportunities. So we will see how we will navigate the compliance and unlock the professional opportunities that are available for us as a chartered accountant. Now, DPDP Act implementation phase. This is the very important thing. We all know that the rules are notified on 13 November 2025 with some rules have been effective from 13 November 25, like definitions that are in rule 1 and 2, DPBI, that is Data Protection Board of India, establishment, rule making powers. This all from Rule 17 to 21, and regulator and rule book infrastructure has come in force from 13 November 2025. Phase 2 is the consent manager framework that will be implemented 1 year after the date on which the rules are notified, that is 13 November 25, 1 year from 13 November 25. 13 November 26 is the date on which the consent manager framework will become applicable. Consent manager registration framework is the thing which is covered, that will be employed from 13 November 26. And what is in consent management? That there is a regulated ticking system for consent, that there is a system for giving, managing, reviewing and withdrawing the consent. Then phase 3, core compliance and rights, 13th May 27. This is the time by which the act will be implemented in full force, that covers scope, concern, fiduciary obligations, data rights, enforcement, full compliance rights and enforcement switch on. So now we are standing in December 25 and the full act will become implemented in May 27. So we have almost a period of 18 months to change our practices and to align our practices in line with the compliance requirements of the act. So understanding the key players, this is the very important thing. The first thing that we have to understand in this act, so that what is the data principle? Data principle is defined under section 2 of the act, that individual to whom the personal data relates. Now what is personal data? Personal data is any data by which we can identify a person. For example, name is a direct identifier of a person, and by name we can identify that person, and name is the direct identifier, and there are some indirect identifiers like age, date of birth, pin code, etc., by which we can indirectly identify a person using other combinations. So data principle, the individual to whom the personal data relates. Whenever we are collecting any data of our client like KYC documents or anything like bank statement, Aadhaar card, salary details, etc., the client is the data principal. Why? Because the data belongs to the client. And the moment that data is shared in a digital way, means if I am having the Aadhaar card of my client in a physical form, and the moment that Aadhaar card is scanned, that Aadhaar card copy is scanned, or that a picture of that Aadhaar card copy is clicked, or that Aadhaar card is shared on email or WhatsApp, it becomes a digital data, and the provisions of the Digital Personal Data Protection Act 2023 will be applicable to that data. If the data is not in a digital form, in a physical form, for example, physical copies of registries, land registries that are not scanned or digitized, on them the Digital Personal Data Protection Act will not be applicable, because the data is in non-digitized form. It is not in the digital form. So my client is the data principal because the data belongs to the client and it is that individual to whom the personal data relates. Now, who is a data fiduciary? The entity that determines the purpose and means of processing personal data. When I am collecting my data of my client, then I am the data fiduciary for my client, because I am the person that determines the purpose and means of processing that personal data, that why I had collected that personal data, I only know, and how I will use that personal data for my task, that I will determine. So I am the data fiduciary. We all are a data fiduciary as a chartered accountant in respect of our client's data. Our CA firm is a data fiduciary when we decide what client data to collect and how to use it for professional services. Because the decision of using the data for a specified purpose rests with us. Now there is another concept in Act that is known as data processor. Now what is data processor? An entity that processes data on behalf of the fiduciary. What it means? As a chartered accountant, we upload our client data on n number of things like Google Drive, OneDrive. Even we gave our client data, PDFs of the client data to various AI tools. So all that AI tools are the data processors for us. Why? Because they are processing the data on behalf of us. We are the data fiduciary, and that software personal, that OneDrive, Google Drive, AI tools like ChatGPT, Gemini, Microsoft Copilot, Perplexity, etc. They are the data processors because they are processing the data on our behalf. Now, examples include cloud storage provider like Google Drive. Like whenever we save the data of our client on Google Drive, so Google Drive is the data processor for us. Tech software vendors like Computex and ClearText, we have a huge amount of our client information for filing of GST and income tax returns and audit purposes on these softwares. or outsource data entry services. If we are outsourcing the data entry services, then that outsourcing service provider is our data processor. And even if we are providing the data to a data processor, we are the solely responsible for the safeguard of the data. There are penalties up to rupees 250 crore for a stringent breach. So we have to be very careful when we are giving any data to a third party, that is a data processor. I hope this is clear to all of you. Then understanding the key terms. There are some terms we have to study to help the act understand better. Processing in relation. What is processing? Processing in relation to personal data means a wholly or partly automated operation or a set of operations performed on a digital personal data, and includes operations such as collection, recording, organization, storage, adaptation, retrieval, use, sharing, disclosure, etc. What it means? If I had collected my client's KYC for any purpose, then the moment I had collected that data, I had processed the data. So I had decided that how to process the data. If I am just storing in my computer database, if I just take the KYC documents of my client and scan them and save them in my computer system, that also comes in the processing. So I will be the data fiduciary in that case also. Organizing, storage, adaptation, retrieval is also covered in this processing. Use, sharing, the moment I used it, I shared it with someone else, I disclosed it to, this all are covered in processing. Specified purpose, that is very important that we have to learn, means the purpose mentioned in the notice given by the data fiduciary to the data principal in accordance with the provisions of this act and the rules made thereunder. What it means: before taking any client data, we have to give a notice to the client that, sir, we are taking your this data for this purpose. Now, what we in practice do nowadays, that we have to change. Suppose I ask the bank statement for my client and the engagement is the income tax return filing for that client. The moment I ask the bank statement, I should give a notice to the client that I want your bank statement, and that bank statement will be used for the purpose of filing of income tax return. If I am giving the specified purpose in the notice that I will be using this data for the purpose of filing income tax returns, then I cannot use that bank statement for audit purposes, because I had not given explicit consent, explicit notice to the client that provide me your consent for audit purpose also. If I want the data bank statement for use in my audit purpose also, then I had to give a fresh notice, or I had to specify in the earlier notice only that I need your data for both the things, that is for filing of income tax return also and for filing of tax audit also. So this is the practice that we have to change. Consent manager. Consent manager means a person registered with the board who acts as a single point of contact to enable a data principal. Data principal is my client, to give, manage, review, and withdraw her consent through an accessible, transparent, and interoperable platform. Now, when we read this, her consent in this act is the first act where she is used and she is also defined. So the gender inequality that was being based, it's being removed. Here reference to she is made, and instead of his that we used to study in most of the acts and earlier acts, her is used. So importance to she is given here, and she is also defined in section 2. Now, what is this accessible, transparent, and interoperable platform? Consent manager has to develop a platform that is used by the data principal to give, manage, review, and withdraw the consent. Four things are there. Give means obtain consent through the consent management system. Manage, modify, or update the consent. Review, if the data principal wants to review the consent and wants to update it, then he should have an option on the consent management system. And withdraw her consent. Very important. If my client has given a consent to me for a particular thing and he or she wants the consent to be withdrawn, then a option of withdrawing the consent should be there with ease that was given at the time of taking the consent. Interoperable platform means exchange platform, that give and take should simultaneously happen on that platform. There are some conditions for a which are to be fulfilled before registering as a consent manager, that we will study in the coming slides. Now, penalty schedule under the DPDP Act. This is the very important thing that we all have to understand. Failure to take reasonable security safeguards by data fiduciary. A very simple thing. A bank person has called me that, sir, your ex-client wants to take a loan from my bank, and so I want the income tax password and login details, which happens most of the cases that banks also has to give the GST password, login password, and give the income tax login password so that they can verify the GST returns file, they can verify the income tax return form. Now, if I provide that ID password directly to the bank person without giving that to my client or without having a consent from my client, that I can share it with this bank personal, because the data belongs to the client. Client is the data principal for this. I cannot share with anyone except with the consent of the client. So if I shared that data with the bank personal, the moment I shared that personal or the password and login of income tax portal and GST portal, there is a penalty for me. What, it's up to rupees 250 crores. Why? Because I had failed to take the reasonable security safeguards that are specified in the Act. There is another penalty, failure to notify personal data breach to board or data principal. Now, when I disclosed my client's confidential data to the bank without client's consent, then what happens? I had to report that data breach because I had made a breach. I was a data fiduciary for my client, and inadvertently I had disclosed the client's data to a third party, that is a banking company. So I had made a personal data breach, and I have to notify that personal data breach to the data principal and to the board. When I had to notify it to the data principal without delay. The means, as soon as I discover that I had made a breach, I should inform my client that, sir, I had made a breach of your data and I had disclosed it to third party. Also, I should notify that data breach to the board, that is the Data Protection Board of India, also within 72 hours of becoming aware of the breach. Otherwise, I will be liable for a penalty that can extend up to rupees 200 crores. So that's a very huge amount. Non-compliance with obligations relating to children's data. There are some special provisions when in respect of children, that before processing any data related to children, that is any person below the age of 18 years, I had to take a verifiable parentable consent. There is a penalty up to rupees 200 crores if I fail to do this. But what means by verifiable parental consent? Verifiable parental consent means that I had to verify by an identity proof issued by the government, identity and age proof issued by the government, that the concerned individual is the parent of that child. I cannot blindly believe on the statement made by the parent that I am his parent. I have to verify also. Failure in observance of obligations related to significant data fiduciary. Now, significant data fiduciary will be notified by government on the basis of volume of and size of the transactions that they process, and on the basis of the sensitivity of the data related process. I believe the large e-commerce entity will be under the gamut of significant data fiduciary, as well as banks and other NBFCs will be covered under the significant data fiduciary because they process a large amount of data. So what is the penalty for failure in observance of obligations relating to significant data fiduciary? It is up to rupees 150 crores. Up to rupees 150 crores is the penalty if a significant data fiduciary failed to observe its obligations. Breach in observance of the duties under section 15, data principal. As a person, we also give our data to n number of organizations on a daily basis. Now, if I want to book a travel ticket, then I will provide my identity details to the travel agent or to the IRCTC or some other airline company. So there I will be the data principal because the data relates to me, and there are some penalties under section 15 and some penalties for non-observation of the obligations of data principal under section 15. What are the obligations of data principal under section 15 is that data principal should give correct and accurate data to the data fiduciary, that the data principal shall not make any grievous or vexatious complaint to the board, and the data principal should comply with the rules and regulations. These are some of the duties that are mentioned in section 15. And what is the penalty for data principal? A very small penalty up to rupees 10,000. Now, breach of any other provision of act or rules made thereunder, if there is any breach which is not covered in the above penalties, that is failure to take security safeguards, failure to notify breach, failure to comply with obligations related to children data, failure to observe obligations related to significant data fiduciary, then there is a residual penalty up to rupees 50 crores. Now, breach of any voluntary undertaking given to board up to the extent specified for breach in respect of which proceedings start. Now, what does this mean? Voluntary undertaking is given to board when the board decides that a person should do something or a person should not do something. Right. So when a board asks for a voluntary undertaking from a person, that give me a voluntary undertaking that you will do something or you will not do something for a proceeding related to any data breach that is being going on with the board, then if the person after giving the voluntary undertaking fails to adhere to the conditions and responsibilities assigned in the voluntary undertaking, then there will be a penalty for breach of voluntary undertaking. And what will be the penalty? Specified for breach in respect of which proceeding start. Means if that voluntary undertaking is in respect of failure to take reasonable security safeguards, then the penalty could raise up to rupees 250 crores. I hope this is clear. Executive summary. The CA is dual mandate. Now, in this act, we have two dual mandate. First, as a data fiduciary, the DPDP Act fundamentally shifts data handling from best practice to statutory obligation. Data handling is now not a best practice, but it's a statutory obligation. CA firm must implement safeguards for the massive volume of sensitive client data within their own practices. We handle highly personal information like PAN numbers, Aadhaar details, bank statements, health insurance records for Section 80D claims, salary slips, and investment portfolio. So any data that we are collecting from the client is the personal data of the client for our purposes, and as a data fiduciary we are responsible for taking reasonable security safeguards so that the data is not leaked or there is no breach of the data and the confidentiality, integrity and availability of the data remains secure. As strategic advisors, simultaneously the act creates substantial new revenue streams through professional service lines. The legislation demands trust, process, rigor, and regulatory understanding, precisely the core competencies of CA. A data breach in a CA firm is now a statutory offense with penalties reaching up to rupees 250 crores. It's not merely a reputational concern, it's a very big, alarming challenge that we have to adopt, that we should be very concerned with the security of our clients' data. Part 1. The CA firm as a data fiduciary. The data fiduciary is, as we have already studied earlier, is defined as any person or entity that determines the purpose and means of processing personal data. A CA firm fit the definition perfectly and comprehensively because we determine that how will the data of the client will be processed. Now, every client engagement involves processing sensitive personal data, from identity documents to financial records, from health insurance details to family member information. This positions CA practices squarely within the regulatory framework, triggering immediate compliance obligations. So we have to adapt ourselves to align with the compliance obligations. Then safeguard 1, notice and valid consent. Consent is the bedrock of the DPDP Act. The whole act is based on the consent. Now there are a few conditions in relation to consent. What is it? It must be free, specific, informed, unconditional, and unambiguous. Now, what do you mean by free? Free is taken from Indian Contract Act. Now, when we say that Indian Contract Act consent is said to be free, when it is not caused due to undue influence, coercion, fraud, misrepresentation, mistake. So the condition should be free. It should not be guided by any of the factors that I mentioned. Specific. We should take the consent only for the specific purpose that we want. Like if I'm using the bank statement for ITR purposes only, I should be very specific to the client that I need your bank statement for this purpose also. Informed. I have to inform my client that I am using this data, I am using bank statement for this purposes. Unconditional, there should not be any condition attached. For example, if I want 10 documents from my client, then I cannot establish a condition there that I would accept the documents only if all the 10 documents are shared with me. I had to take the consent unconditional, that if a client is okay with what he is sharing and if he is not okay with some confidential document, then he will not give me consent for that document, and for any document for which I had not received the consent from the client, I should not use it. And unambiguous, there should not be any confusion or any misrepresentation in the consent that you are taking. Consent should be very simple and clear. A clear affirmative action by the data principal. Pre-check tick boxes won't work now. We have to take a clear affirmative action. And before the acceptance of engagement letter, we should give a consent notice to the client for consent of various documents that we will be requiring from the client. Now, notice of any data breach also to be given to data principal without delay and Data Protection Board of India within 72 hours. Else penalty up to rupees 200 crores that we had also studied earlier. That every data breach notification has to be given to data principal without delay and to the Data Protection Board of India within 72 hours of becoming aware of the breach. The actionable change. The standard engagement letters are no longer sufficient. We cannot rely on standard engagement letters now. They must now include a comprehensive privacy notice detailing precisely what personal data will be collected. We have to tell in the engagement letter what personal data will be collecting, why it is necessary, why we require that particular document for a particular purpose. We have to specify that. For example, if I need the AIS of my client, then I have to specify that I need that AIS for proper filing of income tax return. How long it will be retained? That's a very important. How long I will be retaining it? Now, in some acts, there are time period specified in that. For example, in Banking Regulation Act, there is a time period that the bank will keep the records of the customer for 10 years after the date on which the relationship with customer ends. And the client statutory rights, including withdrawal of consent. So if there is any law which prescribes that the document should be retained for that period, then they have to be retained for that period. If there is no such prescription in any law, then they have to be retained for a period of 1 year from the completion of assignment or on the date on which the consent is withdrawn, 1 year from the date on which consent is withdrawn. They have to be retained for at least that period. And the client statutory rights, including withdrawal of consent. In the notice, we have to also mention that as a client, he has all the rights to withdraw the consent, which is an important right of data principal. Practical example, a client requesting income tax return filing must provide explicit, what would be explicit, clear, documented consent for the CA to access their AIS and TIS data for that specific assessment year. Generic permission is insufficient. We have to take the consent for AIS and TIS, also specifying the assessment year for that we want. We cannot just write that I am filing income tax return and I will want to have access to your AIS, TIS. We should mention that I am filing income tax return for assessment year 25-26, and therefore I would require the AIS, TIS of financial year 24-25. Right. So now we will move ahead. Purpose limitation and data minimization. This is a very important safeguard that we have to take as a chartered accountant. Personal data collected for one specific purpose cannot be repurposed for another without obtaining fresh explicit consent from the data principal. That if we have collected personal data for a specific purpose, then we cannot use that personal data for another purpose without obtaining fresh and explicit consent from the client. Using financial data originally collected for a statutory audit assignment to cross-sell wealth management or insurance services without separate document consent constitutes a direct violation. Of course, if you are using a financial data that you ask for a specific statutory audit assignment and you are using that data to sell wealth management or insurance services, then it is not a good practice and it is a prohibited under law. Data minimization. Firms must collect only the personal data that is absolutely necessary and statutorily required for the specific professional service being rendered. It is very important that we should ask only the relevant documents. We should not ask any kind of unrelevant document which is not relevant to our assignment. For example, immediately discontinue the widespread practice of collecting documents just in case they might be needed later. If a particular assignment is not essential, do not collect or retain it. For example, I am preparing a will for my client. During the preparation of my client, I asked the client the balance sheet of the client. Balance sheet is okay because balance sheet will tell me what is the assets of the client that has to be distributed as per his wish. But if I am asking the profit and loss account statement of the client, then that profit and loss account statement is not having any relevance to the will that is being prepared, because in will I had to distribute the assets of the I had to mention the specific beneficiaries of the asset of that will, and I had nothing to do with the profit and loss statement. So profit and loss statement is not relevant for making a will. So I should not ask the profit and loss statement. Means I should not give my client a message that I want the complete financial statements. I should I don't want the cash flow also. So I will limit myself to only that is required. That statement of assets and liabilities, this is the thing we need. If a particular document is not essential for the current assignment, do not collect or retain it. It's very important. We should start developing our practice in this manner. Next is technical and organizational security measures. We have to implement technical and organizational security measures in our office also. The DPDP Act mandates implementation of reasonable security safeguards to prevent data breaches. Now, what the Act mandates? Act mandates implementation of reasonable security safeguards. For CA firms handling sensitive financial and personal information, this requirement translates into specific measurable actions shall give intimation of every data breach to data principal and data protection board, which we studied earlier also. Now, how we can implement this technical and organizational security measures? Role-based access controls. This is very important. Access to client data must be strictly need to know. An article assistant working on a specific audit should not have unrestricted access to the firm's entire client base. Implement tiered access permissions based on role and assignment. This is very important. Normally in our practice, the first year article has access to each and everything in the organization, each and every folder in the system. That should not be continued. That should be immediately stopped. We should stratify the data in different folders and provide the access of that folder to only the person who is responsible for the assignment that is related to the data stored in the folder. We should not provide access to all and everyone in the organization. That's very important. Implement tiered access permissions. We should granularize this and we should have a tiered access permissions based on role and assignment. Only that person who has role in that assignment should have access to that relevant data, and other persons in the organization should not have access to the data. Data encryption, that is very important. Client data must be encrypted. What do you mean by encrypted? Means we can have a password. Both at rest stored on servers, laptops, or external drives, whatever data that we are storing of our client on our servers or laptops or external drive, that should be encrypted. They should have a password. And in transit, now when transmitted via email or cloud platform, because the biggest mistake is when we are sharing data through email or WhatsApp. If by mistake we select the wrong sender, wrong recipient, sorry, the wrong recipient, if we select the wrong recipient, then the sensitive client data will be shared with a third party which has no right to know about the client data, and this in this way we will result in a breach of client's data and we will be deemed as fail to take reasonable security safeguards. So password protect all sensitive documents attachment. This is the minimum baseline that we should take, that we should password protect and we should encrypt all the documents that are in relation to our clients. Physical and digital security, that is also very important. Secure physical access to offices where data is stored. Physical access should be secured. Implement robust password policies, multi-factor authentication for critical system, and regulatory security audits that we also should do. What is a safeguard for? This is also very important. Managing data processes, third-party vendors. CA firms rely extensively on third-party service provider who process data on the firm's behalf. Under this act, the vendors are classed as data processor. Right, sir? What is data processor? Data processor is any entity that is processing data on behalf of data fiduciary. So common examples is cloud storage platforms like Google Drive, Microsoft OneDrive, and Dropbox. Text preparation filing software, Computex, Genius, ClearText, practice management system, outsource data entry or scanning services like I Love PDF, which many of us are using. Now, whenever we use any kind of this data processor, have we gone through the privacy policy of the data processor? If you have time, please go through the privacy policy of I Love PDF. There, we will know how that data of our client is used by that data processor for continuous improvement and monitoring. So that data is being shared with some persons in the organization of the data processor. And now, before engaging any data processor, we have to enter into a valid contract with the data processor. We cannot appoint a data processor without entering into a valid contract. That's a very important practice shift that we have to make, that is being prescribed in the act. And when the provisions of uh, agreement will come into force, then it will be very difficult for us to implement. So we start implementing right now only, that we should start entering into agreements with our data processors. What is a critical safeguard? Valid written contracts must be established, ensuring these data processors maintain DPDP Act compliance standards. Because as a data fiduciary, we are the person responsible for any breach that is caused by the data processor. Data Protection Board will levy penalty on us as a data fiduciary. Although we can then sue the data processor for damages, but primarily we will be the person who will be the culprit in the eyes of Data Protection Board. Crucially, if a vendor experiences a data breach involving your client information, primary legal liability still rests with the CA firm as a data fiduciary. The primary liability is with the CA firm because CA firm is using the client's data. Now, what we have to do? Now, if you are using a income tax or a GST software like Computex or ClearTax, there also there are a lot of our clients who had ceased to be our clients, but still their data is being stored on the software. So immediately assess all the clients list that is being maintained by the software and start scanning that which are the clients who had ceased to have relationship with us. Start, and if the seizure of relationship has a period of more than 1 year, if it's been more than 1 year, then the client has ceased to be a client, then give a notice to the client that we will be deleting your data within 48 hours as prescribed in the rules. So start scanning what unnecessary data we have in respect of our client. Professional opportunities for chartered accountants. This is a very important thing. The DPDP Act creates substantial new revenue streams for CA practices. The legislation requirements for trust, process rigor, audit capabilities, and regulatory compliance align precisely with the professional competence CAs have cultivated for decades. This represents a significant market opportunity. How it represents, we will learn. The consent manager framework, very important. Who is the consent manager? The Act introduces consent managers. Consent management system, interoperable means exchange technology platforms enabling individuals to manage, review, modify, and withdraw consent across multiple data fiduciaries through a single unified dashboard. A consent manager can have n number of data fiduciaries onboarded onto its platform. So consent management system is basically for data principals to manage, review, modify, and withdraw their consent when required. Consent manager is not mandatory, but it's recommendatory. The word uses may. The consent manager serves as a trusted intermediaries between data principals and data fiduciaries, maintaining auditable consent records and facilitating seamless consent management. They have to maintain auditable consent records for submission to Data Protection Board as and when required. This is a high technology, high trust business model with significant scalability potential. There is a huge demand for consent managers will be there in coming days. Consent manager eligibility and CA positioning. What is the eligibility specified in the rules? Entities seeking to operate as a consent managers must register with the Data Protection Board of India as an Indian company with net worth not less than rupees 2 crores. This is the first condition, that they should have a financial capacity, that they should form an Indian company with a net worth not less than 2 crores. Minimum net worth should be 2 crores. And what is net worth? Is the total of assets minus total of liabilities. While final operational rules are still awaited, preliminary indicators suggest registration will require demonstration of significant technical infrastructure capability. As a concern manager, they should have significant technical capabilities, robust security protocols, and operational scalability. Direct model. Now, how CAs can benefit as a concern manager? CAs can establish separate technology-enabled legal entities specifically designed to meet the technical requirements and register as authorized concern managers. Now, those firms who are able to meet the 2 crore paid up capital net worth criteria, they can register as a concern manager after being incorporated as a body corporate in India. Advisory model, those firms which are not able to fit into the financial criteria, they can provide process audit, compliance review, and assurance services to established concern manager platforms, leveraging C expertise in controls and governance. So what we have to do, if we are not able to form a concern manager entity ourselves, we can play advisory role in the concern management system that is being developed by the other entities. Partnership models, from strategic alliance with technology firms contributing regulatory and compliance expertise while partners provide the technical infrastructure. We can also partner with someone who had the financial and necessary capacity, and we can provide the compliance expertise, and they will provide the infrastructure. So this manner, CAs can play role in concern management system. Opportunity to data protection officer. Every significant data fiduciary must appoint a data protection officer. That must be an individual. So entities classified as SDFs under the Act must mandatory appoint an individual as data protection officer based in India. DPO be the point of contact for grievance redressal under the Act. For significant data fiduciaries, it is the data protection officer who will be the point of contact for any grievance of data principal. Service model, chartered accountants can offer virtual DPO or DPO as a service arrangements to small and medium enterprises. This involves providing ongoing compliance oversight, policy development, training programs, and regulatory liaison. Now, all firms are not that well positioned that they can afford a full-time data protection officer, even if they are significant data fiduciaries. So there may be cases where some firm can offer virtual DPO or DPO as a service, where they can avail the services of a chartered accountant in grievance redressal mechanism. Target client example, e-commerce startup processing customer payment details, delivery address, and purchase history. The business handles substantial personal data but cannot justify the cost of a full-time in-house privacy specialist. The CA firm acts as an outsourced DPO, providing expert guidance at a fraction of the cost. Now, as an e-commerce entity, they have to keep and maintain the records of customers like delivery address, payment details, and their purchase history. And due to start of the business, they may not be in a position to afford a full-time DPO. So there, the CA firm can act as their outsourced DPO. So first opportunity was in consent management system. Second is as a DPO, data protection officer, for significant data fiduciary to help them in their grievance redressal. Grievance redressal services for entities other than significant data fiduciary. Now, universal statutory obligation is there. Every data fiduciary, regardless of size or turnover, must establish a functional grievance redressal mechanism to handle complaints from data principals. What it is mentioned that every data fiduciary, whether it is small, whether it is big, regardless of size or turnover, means even our CA firm also has to maintain a grievance redressal mechanism to handle complaints from data principal. And why we want a grievance redressal mechanism? Because in section 15, the rights of a data principal, right to grievance redressal is a right of the data principal, and so a grievance redressal mechanism has to be developed. Complaint management. What will we do then that the grievance redressal service? Receive, record, and systematically track all data related complaints from individuals regarding privacy concern, consent issues, or data access. First, the data grievance officer has to manage the complaints, that whatever complaints he is receiving from the data principal, he has to receive them, record them, and systematically track all data related complaints regarding privacy concerns and consent issues. Timely resolution, investigate complaints. The data redressal mechanism, grievance redressal mechanism should investigate complaints thoroughly and provide documented responses within statutory timelines, ensuring compliance with procedural requirements. What is the timeline? Grievance to be redressed within 90 days. It is specified in Rule 14 that any grievance of the data principal should be redressed within a period of 90 days. Published contact. Entities should publish a contact information of the person who is responsible for handling grievances. So, serve as the publicly designated point of contact for grievances with contact details prominently displayed in privacy notices and on company websites. So, company should mention the contact person of the person who is responsible for addressing the grievance of the data principal. For smaller clients such as MSMEs, CA firms can provide outsourced GR services, handling the administrative burden professionally whilst ensuring statutory compliance. For a very smaller clients, CA firms can provide outsourced grievance redressal services also if they cannot afford a full-time grievance redressal officer or a person who is assigned the responsibility of managing the grievance redressal system mechanism. Data protection impact assessment, consulting and audit. Now, data protection impact assessment is for significant data fiduciaries, and data audit is also for significant data fiduciary. Significant data fiduciary has to appoint a data auditor, and they have to undertake a periodic data protection impact assessment and a data audit every 12 months. Significant data fiduciaries must appoint a data auditor and conduct periodic on-scene every 12 months data protection impact assessments and audit before undertaking any high-risk data processing activity. So before taking any high-risk data processing activities, they have to assess the impact of such activity. Help in qualifications of data auditor is not prescribed yet, right? Because we don't know who will be the qualified as the data auditor. It is not specified yet. We are waiting for that. Data flow mapping, document how the personal data moves through the organization. That is very important when you are doing the data protection impact assessment. That document how personal data moves through the organization from collection points through processing systems to storage and eventual deletion. We have to see the flow of data, how the data is moving within the organization from collection to processing and then to storage and the eventual deletion. There is 48 hours notice from the time period mentioned in the act, that is 1 year. After 1 year plus 48 hours notice is mandatory before deleting any data. Identify all touch points. Also, CS can act as a help in audit of consent manager. So consent manager have to build a auditable trails so that auditable trails CS can help in it. Mitigation strategies recommend specific actionable controls and safeguard to identify risk. Develop implementation roadmaps with prioritized actions based on risk severity. We have to develop a implementation roadmap with priorities on high risk items. Privacy risk identification. Analyze business processes to identify potential privacy risk and vulnerabilities. Consent gaps. We all know what is risk. Risk is the probability that a vulnerability will be exploited by a threat. So we have to identify that risk. Documentation and reporting. We have to prepare comprehensive data protection impact assessment reports, demonstrated due diligence, suitable for presentation to management boards and regulatory authorities. The service is analogous to internal control testing and risk advisory work, familiar territory for CAs, but with a specific focus on data privacy risk rather than financial control. What it means, it's similar to internal control and risk advisory, but with a specific focus on data privacy risk rather than financial controls. So this is the another opportunity for chartered accountants. Path forward, the action points. Now, what are the action points that we have to take in our practice? Immediate internal compliance, audit your firm's current data handling practices. That is very important. Update engagement letters with comprehensive privacy notices. Implement role-based access controls and encryption protocols for client data. That is very important. First, we have to assess our current handling practices. Then we have to update the engagement letters with comprehensive data privacy notices that should precede the engagement letter acceptance and engagement acceptance. Implement rule-based access control. We should implement rule-based access controls in our organization and encryption protocols. Client data should be encrypted. Vendor contract review. Assess all third-party data processor relationships. We have to assess the third-party relationships with any software personnel or any OneDrive, Google Drive on which we are sharing the data. Ensure valid contracts are in place with appropriate data protection clauses and liability provisions. We have to ensure that valid contracts are there which cover appropriate data protection clauses. There should be a clauses related to data protection and liability. Service line development, identify which opportunities like data protection officer services, data protection impact assessment services, consulting, or grievance redressal outsourcing align best with your firm's capabilities and client base. Develop service offerings, and we have to see in what role our firms fit the best. As for consent manager, there is a minimum requirement of 2 crores net worth. So all firms will not fit into that consent manager criteria. So that firms can act as an advisory for consent management systems, as an advisory for consent implementation of consent management systems. Capacity building, capability building, invest in training for partners and senior staff. We have to do that. And consider especially certifications in data privacy like CIPM and CIPP. to enhance credibility in this emerging practice area like certified information privacy manager and certified information privacy professional. These are some of the courses that you can do in data privacy field. The DPDP Act represents both obligation and opportunity. This is the whole nutshell of the discussion that we had made, that it represents both obligation for us as well as an opportunity. Firms that act decisively ensuring their own compliance while building advisory capabilities will establish strong competitive positions in this rapidly growing professional services market. So firms that will act decisively, we have to do two things. First, we have to change our practices, the way we are working on it, and then we have to implement that practices on our clients' workplace so that we will get rewarded for that. First, we have to change our practice and then we will implement these practices at our client's place and earn revenue from it. So thank you so much for your patient listening. This is my contact details and a scanner is also attached for you. I am ready for the questions. Any questions?
Yeah, sir.
Sure.
First question is from Chennai. Why DF is made liable for non-compliance of Act by Data Principle under Section 8(1)? If so, how can we comply?
Sir, DF is liable because DF is the person who is collecting data on behalf of the data principal. The data principal is providing the data to the DF. So when you are collecting the data from a data principal, you becomes the DF. And so in the act, DF is held responsible and DF is liable for non-compliance of with a penalty that may range up to rupees 250 crores.
When consent needs to be specific as per Section 6, can we use the ENG letter to obtain consent among the other things as per the format provided by the ICI? Engagement letter to obtain
No,
consent among the
sir, Sir, engagement letter, you have to specify for what purpose you are taking the consent. I cannot write that I am having general permission for all the documents. I have to specify that if I am wanting documents like PAN card, bank statement, Aadhaar card, salary slips, then I have to uh, mention in that consent what is the justification for asking PAN card, Aadhaar card, salary slip, and bank statement. Justification for each document should be there. So that is the purpose of data minimization, that we ask data only for the purpose that we require.
Next question is the data principal pays 10,000, but DF pays 50 crore for not ensuring compliance of data principal under Section 8.
Yeah. Sir, that's been defined in the act, and as a chartered accountant, we are also a data principal on 100 of platforms. Whenever we are booking travel ticket, we are a data principal. But when we are as a data fiduciary, we are acting as a data fiduciary. Our responsibilities and our obligations increase, and that is specified in the act. And why it is being made? Because the government thinks that data fiduciary is a more big entity because it is collecting the data on behalf of its data principal. So they had mentioned in the act that the provisions for data fiduciary will be more stringent when compared to data principal, and in the act there is not a big liability has been assigned on the data principal. They have only 3-4 functions that have to do, that they should comply with the rules and obligations, and they should not make frivolous complaints, and they should provide the correct data. This is only the 2-3 responsibilities that are assigned to the data principal, while there are huge responsibilities that are assigned to the data fiduciary.
Any provision for data localization, storage, transfer, etc.?
Uh, Sir, as such, there is no provision for data storage. The only thing that is mentioned in the act is that we have to take a reasonable security safeguards as a data fiduciary. And what it means by reasonable security safeguards means safeguards so that the availability, integrity, and confidentiality of the data can be maintained, and it should not result in unauthorized disclosure or sensitive disclosure of data. So that is the thing. As the act will move forward, as the more things will get implemented, there may be some provisions, some guidelines related to storage that can also come. Until now, it is only established that storage should be on a secure platform.
Is law degree required for a DPO or a IT degree?
Law, sir, it is not mentioned in the act or the rules right now. Only eligibility that is being mentioned is with regard to concern manager, that the concern manager should be a body corporate with a minimum net worth of rupees 2 crores. Neither the qualifications of the data protection officer is specified. Only it is written that the data protection officer should be an individual. Neither the qualifications of the data auditor is prescribed. So we all are waiting for that. That as soon as the qualifications will be prescribed, we can update ourselves.
Next question is, can we ask peer reviewer to sign undertaking like NDA, etc. to do work in CA firm?
Pardon, can you please repeat the question?
Can we ask peer reviewer to sign undertaking like NDA, etc. to do his work in CA firm?
Yeah, of course, if a peer reviewer is taking data from the CA, like if I am doing a peer review of my fellow CA, then the fellow CA is the data principal because the data relates to him, and I am the data fiduciary because I am collecting the data from the fellow CA. So as a data fiduciary, it's also my responsibility to give notice to the fellow CA that I will be requiring these documents for this peer review purpose assignment, and for this I require your explicit consent.
Uh, what steps are to be taken before using any software in a CA office for filing of documents with MC and Income Tax Department?
Sir, if you are using any third-party software for storing the records, then the first thing you have to do is you have to enter into a legal contract with the data processor because you are uploading your client's sensitive data onto that data processor platform. And in the event of any unauthorized disclosure by that data processor, you will be held responsible if you don't have a contract or so. So if you have a valid contract, then it can save you from the severe obligations that have been specified in the act, and it can act as a defense in front of the Data Protection Board of India.
Okay. Is this act applicable to charitable institute?
Sir, it's applicable to everyone, sir. Even government is included in this act.
Okay.
In the earlier
Will
act
they
that was there, the government was not included, but now in this act they had specifically mentioned that the government entities are also covered in this.
will there be any conflict if DF and consent manager are same?
Data fiduciary and consent manager are same, sir. If the data fiduciary is a company with a minimum capital of net worth of 2 crores, then data fiduciary can also act as a consent manager. And regarding the conflict of interest can arise, but if the data fiduciary and the consent manager is the same person, then there are additional obligations on the data fiduciary to act in a very transparent manner, because as a consent manager, you have to respect the rights of data principals. So I would generally suggest that it would be better if the data fiduciary and the data and the consent manager are separate persons, so that accountability can be specifically distributed. If both are same persons, then accountability would be difficult to distribute.
Next question is of Vinit sir from Bangalore. Will ICI provide some standards template to contact to be entered in between CA firm and data processor like Computex?
Sir, it's a very good suggestion, sir. Thank you for the suggestion. We can write to the ICI that it will be great if ICI provides such kind of templates. It will help us a lot, sir. That's a very good suggestion. Thank you so much.
Next is how to handle a case of a salary TDS return. Should the CA take consent from each employee of the client for use of personal
Sir,
data?
in salary TDS return, very good question. In salary TDS return, CA is the data fiduciary. No, so in the salary return, CA is the data fiduciary for the client, for the employer, but CA is the data processor for the employee. Are you getting my point? Because the employer has provided the personal data to the employee has provided his personal data to the employer, and so employer is the data fiduciary for that employee. And since that employer is providing that data to us for processing, so we are the data processor for the employer, but we are the data fiduciary for the employer. So we don't have to take a separate consent from each and every employee. That is the responsibility of the employer to take separate consent from each and every employee, because employer is the data fiduciary in relation to employee, and we are the data processor in relation to employee, because we are processing the data as per the instructions of the employer.
Yeah. Next question is of Pooja ma'am from Hyper. Should we
Mhm.
take consent from investor in case of AIF client due diligence? The investor joined a year back.
Yes, ma'am. It has been mentioned that if you to align with the best practices of the Act, it is better if you start taking consent from this your investors, because when the Act will be implemented in full force, that is by May 27, then all these things we have to do, and if we are not updating ourselves to these practices, then it will be very difficult to update at the last stage. So I request you to start updating this practice from now onwards.
Okay. Continuing question, as an investment manager of an AIF, what are our obligations under the DPDP Act regarding the data of contributors?
Sir, there is no separate provision relating to in AIF. What is that? If contributors is your data principal and you are the data fiduciary, so the obligations that are specified for data fiduciary will be applicable in your case also. And if as a alternate investment fund you are a significant data fiduciary, then obligations related to significant data fiduciary will also be applicable in your case, sir.
Continuing Pooja ma'am's question, can we save the data of client on our local server? Can we save the KYC of client on cloud storage? What is the procedure?
Sir, if you are saving on your local server, if you are not, that is local server, that is your own server, then there is no data processor involved. So you are the data fiduciary and the client is the data principal. But if you are saving the client data on OneDrive or Google Drive, then you are accessing the storage services of a separate entity. And in that case, the Google Drive or OneDrive will be the data processor for your client.
Next question is of Sushil sir from Delhi. Sir, can you please brief the steps to be taken by CA firm to prepare itself for DPDP Act?
Sir, first step is the do your thorough analysis of your firm, that where you are standing in respect of these practices, that whether you are entering into contracts with data processor, whether you are giving the client's data to only the client who has given you the data, or you are forwarding that data to the family members also, to the banks also, and whether you are giving notice and taking consent from the client before taking any document from the client. It is the most important thing that we have to update ourselves as a data fiduciary.
Next question, continuing Sushil sir question, can you please brief this? What are the specific format for various forms or permission have been prescribed?
So
Any
formats we
specific
have to,
formats?
the formats are not prescribed yet. We for consent and for notice we have to make our own formats.
Okay. That's all, sir. Thank you for such a great session. Your thoughts on the topic were truly enlightening. I'm sure the participants have gained knowledge from your experience. Thank you for your valuable time. And a special thanks to CP committee for making this webinar a great success.
Thank you so
Last
much,
but
sir.
not the least, I thank these wonderful participants for being so patient and participative. Thank you all very much, and have a
Thank
wonderful
you so much.
evening.
Thank you so much, Shubham sir. Thank you. Thank you. It was a great
Thank,
interacting with you.
thank you,
CP committee would like to thank both our faculties and Shubham sir for the insightful sessions. Thank you so much.
Thank you,
thank
Akshay.
you,
Thank you. Thank you, sir.
thank you.
Vinuji, we can